So welcome back. This is lecture 2 of Laws and Ethics for CMA Intermediate June 2023 attempt. Okay, and we are doing Indian Contract Act 1872. So yesterday we reached till here. Okay, we were talking about communication of revocation. Okay, so communication, basically communication of offer, communication of acceptance. Okay, then revocation of offer and acceptance, then communication of revocation of both. Okay, so I told you that I'll show you a table, right? So fine, so this is the table. So after we go through this table, it will be crystal clear for you. Whenever it comes to communication of offer acceptance, then revocation of offer acceptance, and communication of revocation of offer acceptance. Okay, then you can directly refer to this table. It will be very straightforward. Okay, just a moment. Someone is joining in. Okay, hello Sanjana. So we are just about to start.
Good evening, sir.
Good
Yeah.
evening. And okay, so what I'm going to do from today is, because just to avoid a mixing up of languages, okay, for 30 minutes, we'll go straight away in English, okay, without mixing it, we'll go for English because some students do not understand Hindi. So just to keep the continuity, 30 minutes in English, and after this, I will give a summary, let's say of about 10 minutes, okay, 5 to 10 minutes, whatever is required, that much summary I'll give, okay. So this will, because of this, then there will be no mixing of languages. Although initially I'll be doing in English for half an hour, the whole thing I'll summarize in Hindi, okay.
Fine, sir.
Okay. So now yesterday where we ended is this, okay, where we talked about communication of revocation, basically communication of offer, acceptance, okay, and then revocation of offer, acceptance, and communication of revocation of offer, acceptance. So one thing what I told you is, if say this is Mr. A, this is Mr. B, okay. So if Mr. A is communicating an offer to Mr. B, does it mean that the contract has been completed? If Mr. A, okay, is communicating an offer to Mr. B, he's saying, I'm giving you this offer, and Mr. B has either read it or listened to it. Okay. So this doesn't mean that the contract has completed, correct? Contract is completed, but the communication is completed, correct? So when legally cases are decided, they see all these things, whether the communication is completed. If the communication itself is not completed, then there is no question of further contract, correct? So what courts basically see is whether the communication is completed, they see this, and then they will consider about the whole contract completion. So they basically decide cases on these basis. That's why we are separating communication from the entire contract. Okay. So now, so you can see the first thing is, this is your offer side. Okay, that is, this is A. Okay, this is A, and this is your acceptance side. Okay, this is our, let us say, this is B. Okay, acceptance side. This is offer side. Okay. Now, first thing is, what will happen is communication of offer. Okay. So communication of offer, when it is complete. Complete when it comes to the knowledge of the acceptor. Okay. Why? Here, so here we are not talking about from both parties' point of view. Why? Because see, when offer is made, there is we do not have an acceptor till that time. So it's only the offer which is in existence. Whereas when you make the acceptance, you already have the offer which is made, right? So offer is already made. So which is why for acceptance, you have to see whether it is completed, okay, from the point of view of the offerer and from the point of view of the acceptor. But here there is no acceptor when he is making the offer. Okay. So which is why we are saying for offer, communication of offer is complete when it comes to the knowledge of the acceptor. The communication for offer is only what you have to see is, okay, he has communicated and he has understood it, okay, or he has read it, okay, right, or he has listened to it, whatever, right, whether it is oral or written based on that, okay. So that is why for from the offer side, communication of offer, once he has said, he has listened, it will be completed. We'll say that communication offer is completed. So basically, actually what we're trying to say is from both their point of view, it is completed. Okay, actually speaking, from both their point of view, it gets completed. The communication of offer. Okay. So only thing which is required is the communication must reach the acceptor. That's all. Okay. But now when we come to communication of acceptance, okay, so as I had told you earlier, here it will be as against the proposer, okay, as against the acceptor. There will be two things, okay. Because here what is happening? He is saying something. Here he is saying something and he has listened. The case is over. You do not have to see two things, okay. And since when the offer originates, there is nothing at that point of time, okay. There is no other thing which you have to look to, so you don't have to worry about it. But when you are accepting, you also have the offer which is already there, okay. So which is why for acceptance we see when it is completed against the proposer or against the acceptor, okay. So against the proposer, I had told you, okay, earlier I told you that, say this is the proposer, okay. He has given the offer, right? Then this acceptor, let me show it with pink color, okay. He has said okay and he has posted it. Let us say this line where I'm ending it, this is the post line, okay. Okay. This is the line where he has posted it. So it's out of his power now here. Okay, so this point basically. Right? So we are saying at this point, okay, it is complete as against the offerer. Because offerer has given an offer, this person has accepted and he has posted it. It is out of his power. So from this point of time, he has no power to revoke it. Okay. Right. So this will be as against the proposer, if you see. When put in a course of transmission to him to be out of power of the acceptor. Okay, that's why we have shown you an image of post box here. Right, so against the proposer, when the acceptor is put in a post box, okay, it is completed. Post box, I am saying considering that he is accepting through postal letter, okay, or whatever be the mode, it will be that mode, right? So now as against the acceptor, now it will be same as your offerer, okay. When offer was communicated, what happened? It was completed when it came to the knowledge of the acceptor. So here it will be as against the acceptor when it comes to the knowledge of the proposer. That's all. Second point is exactly the reverse of this. Only thing is that for acceptance, there will be against the proposer and against the acceptor. 2 points will be there. Here, there will be only one thing offered. He says, he listens to it, over. Okay. There is nothing other. There's no other thing which is pending. But here, even before the acceptor accepts and does something, already the offerer has made the offer that is pending. So from his side also you have to examine. Clear? This is clear. This point, this is the basic point. Once you understand this, other points will be very simple. Okay. This is the basic thing. So communicate. So here what we have talked about is communication. Okay. Not the offer or acceptance. Communication of offer, communication of acceptance. Now, what is the importance of communication of offer or acceptance? Importance is for revocation. Okay. So if you see this, second point is revocation of offer and acceptance. Okay. So here, what are we saying is, here, see, revoke before the communication of acceptance is complete against the proposal. That is, complete against the proposal means you can revoke before this point. Okay, when he is putting, acceptor is putting in the post box, before that point you can revoke the offer. Okay, and for acceptor, revocation of acceptance, you can revoke at any time before its communication reaches the proposer. That is, this person is accepting. Okay, this person is accepting, he will accept and he will post it, correct? So he's put in the post box here. Okay, after he has put in the post box, this will then reach this person, correct? Two stages will be there. One is here, at this point it has become out of power of acceptor. Okay, but the proposer has not yet read it. He doesn't know that this person has accepted his offer. Fine. So then the letter will be delivered to the proposer. Okay, so acceptor can revoke it any time before it reaches the proposer. Okay, so if he can, revoke it at this time, okay, at this time, or at this time, okay, at this time, anytime he can revoke. Okay, but not at this point. Once it has reached the proposer, he cannot revoke it. After that, penalty clause will apply. Clear? Okay, so basically here, in short, if I were to tell you, revocation of offer is this point. Okay, revocation of acceptor is this point. Okay, so basically from the first point itself, we have done the second point also. Fine. Then next is, okay, now first what we did, we did communication of offer and acceptance. Okay, communication. Okay, then we did revocation of offer and acceptance. Third thing will be communication of revocation. Here we are communicating the offer. Here this revocation also has to be communicated. Okay, so when will the communication of revocation be completed? Okay, so for this it is fairly straightforward. Okay, and good thing is it is same for both. Okay, this, if you read this point and if you read this point, it is exactly the same. Okay, so communication of revocation is same for both. So here, as against the person who makes it. Okay, whether the offerer, both can revoke, right? Offerer can also revoke his offer, acceptor can also revoke his acceptance, correct? So if the offerer is revoking it, so here let us say as against the person who makes it. Okay, if it is an offer, it will be offerer. If it is a revocation of acceptance, then it will be the acceptor or the offeree. Okay, so as against the person who makes it, when it is put in a course of transmission to be out of power of the person who makes it. Okay, here also if you see, revocation of, this is revocation of offer, revocation of acceptance, both are same, single set of points. Okay, as against the person who makes it. Okay, when it is put in a course of transmission to be out of power of the person who makes it. So basically speaking, what we are saying is, so communication of revocation. Okay, okay, so here what we did, what we said is, for offer, okay, he has made the offer. Okay, and this person has accepted it. Okay, and he has put it in post here in this line. Okay, so if he has to revoke, okay, if this person wants to revoke, he has this much of time. This person, offerer, has to revoke, he has this much of time. Okay, that is till here. Okay, he has time till here to revoke. Okay, communication of revocation, what we said is, okay, okay, it is communication of revocation will be complete, okay, when the other party has posted his letter, okay. So after this you cannot revoke, basically. After this point you cannot revoke, okay. If we see this again in detail here, so communication of revocation of offer as against the person who makes it, okay, that is here. If offerer is revocating when it is put in a course of transmission, okay, to be out of power of the person who makes it, okay. When it is put in a course of transmission, sorry, I just got it a bit wrong here, okay. It's not like that, okay. So actually speaking, now communication of revocation is, okay, so here whatever I showed you is not communication, okay. This is revocation, okay. He can revoke it from here. He has sent his offer here, okay, and from here he has replied it, okay. So till this point of time he can revoke, okay. Now we are saying, okay, now he wants to revoke, so he will communicate revocation. So when is communication of revocation complete? Not revocation, okay. For revocation you will have time till here, but for communication of revocation, okay, now when this person is writing a letter of revocation and he's posting it, and as soon as he has posted it, okay, say he has posted it here, so here communication of revocation is complete, okay. Again, we are not saying revocation is complete. So once he has posted, his communication is complete, okay. So communication of revocation, for him also it will be the same, for only for communication of revocation. When he wants to revoke, he has accepted, he wants to revoke it, okay. So when he is revoking, he is communicating. When he has posted it, his communication of revocation is complete, okay. So just don't get confused between revocation and communication of revocation. Communication is when you have successfully said your point, okay. So these points, why they are used is, okay, this is when he has communicated, and all these are used by courts to basically find out whether the communication has been made before this period or not. In the end, this is the key period, okay. He has made the offer, he has posted the acceptance. So they will see, right, whether he has made the communication, okay, before this period or not, okay. So that is the thing about revocation of communication of revocation. So if we read this now, so this is actually very simple, straightforward, okay. As against the person who makes it. So let's say this person, offer side, is making the revocation, okay. When it is put in a to course of transmission to be out of power of the person who makes it. Person who makes this is the same person, correct. So we are not talking about the other person yet. So one person, when he is putting it, okay, now say he has realized that, oh no, I have made a wrong offer, he wants to revoke it. So he will communicate revocation and he will post it, okay. As soon as he has posted it, okay, his communication of revocation is over, okay. Revocation is not complete, communication is complete, okay. I already told you before that don't get confused between communication and revocation, okay. Communication is when you have, so see, if you have not communicated at all, then your contract will fall flat there. There's no contract if it is not communicated. So court will see this also, whether you have communicated. Okay, he has communicated. See, you have communicated, they'll say, but this was the point of time when your acceptor has posted the letter, okay. Okay, but your whatever you have communicated, okay, it has been done after he has posted this letter. So which is why your revocation does not hold good. This is what the court will say. But you don't have to go into too much of detail, okay. You only have to see from your point of view the point at which revocation is complete. Communication of revocation is complete. Okay, that's what you have to know. So these 2 points, both these points, okay, basically these both are exactly the same, correct? This and this are same points, right? So for communication of revocation from the offer and acceptance side. So when is it completed? If I were to tell you again in short, when is it completed? When he has communicated the revocation, okay, and posted it. Yes, posted it. And if he wants to revoke acceptance, then when he has communicated the revocation, okay, and posted it. Okay, these are the 2 points what I have drawn here. This is what this whole thing is telling you, whole paragraph. Okay, this is what it is telling you. Okay, so this is as against the person who is making it, right? But again, for revocation, both things are already in existence, right? You are revocating, okay, because you have an offer side, you have an acceptance side. Okay, letter might have reached the acceptor, right? So again, you have to say from both point of view. Okay, so as against the recipient, it is straightforward. When he comes to know that the person has revoked it, okay, then it will be complete as against the recipient. Okay, he has revoked it here, it's complete against him. But when this information reaches here, this person, then it will be complete against him. So court will not just see whether it is completed against one person, they will see that it should be complete against both the people. Okay, based on that it will be defined. So but these are stages of communication which are defined to have clarity in the cases. Okay, fine. In the end, what is the main thing? Offer reaching the acceptance, the person, and he has accepted. That is the main thing. And revocation, when the person is successfully revoked. Communication is only help us study the time, okay, to find out whether if the person has revoked, has he done within the proper time or the time was barred. Okay, like for example, you go, you have filled a form somewhere. Okay, all many times happens, it would have happened to you definitely, that you have filled a form for a college or somewhere. Okay, and then you have decided that you don't want it. Okay, when you go back to claim your money, many times this is the time is out. Okay, so that time, okay, that is the time for your communication. Okay, that is over now. So is this clear? This is one point where it this is quite confusing to students. Okay, even at the final level, uh, and afterwards, although you don't have contract act at the final level, but this point remains a doubt always. Like, what is communication? What is revocation? And this, so this is what we have summarized in short here. Okay, so this is what you have to understand. Very straightforward. Just go through again, you will understand. First thing is communication of offer. With communication of offer only things start. So very first point is communication of offer. This is very straightforward when it comes to the knowledge of the acceptor. Okay. And next is, so from acceptance side. Now in acceptance side, you already have an offerer. So from both point of view, you have to say against the proposer when he has put in a course of transmission to him. Okay, that is this acceptor is putting in a course of transmission. Offerer has sent his offer, he is saying yes or no, whatever. Okay, and he is posting it. This line, let us say, is the post box. Okay, so this is your point 1 against the proposer. So basically, till the communication of offer is complete, okay, communication of offer and acceptance. Contract is not just offer. Okay, it is offer and acceptance. For him, for the whole thing to be completed, the communication of acceptance also must happen. So this is the time till which he has to revoke it. Once he has posted it, he cannot revoke it. Penalties will apply. Okay, so one point you need to appreciate here is the offerer has the time to revoke, not till it reaches the acceptor. Okay, so it reaches the acceptor thinks about it, and he accepts and posts. Till that time he has time to revoke. Okay, not till the time when it has reached the acceptor. It has reached the acceptor doesn't mean that he has accepted. So till he accepts, he still has the time to revoke it, offerer. Okay, and okay, so this is complete as against the proposer when it is put in a course of transmission to be out of power of the acceptor. Okay, and against the acceptor when it comes to the knowledge of the proposer. This is the first point. Okay, and revocation is straightforward. I said, just don't think too much. Once you just remember the first point, this revocation is this, and this revocation is this time. Okay, so you have to revoke before communication of acceptance is complete against the proposal. Okay, that is this point. Okay, here at any time before communication reaches the proposer, that is when it comes to when the communication of acceptance is complete against the acceptor. Okay, that is this point. So revocation offer is this point, this is this point straight away. Okay, 2 points are over. And then lastly, communication of revocation, again from two parties. Okay, so for both the parties, okay, this point is same. This is also, you can say, same as this. Okay, points are same exactly for both of these. Okay, so basically what we are saying is, okay, this is a common point. Okay, for offer side as well as acceptor side. For offer side, what is this? We want to read it again. Just remember in short that he has posted it. Yes, he doesn't want the offer now. So he has written, no, I don't want to continue with my offer. Okay, whenever he has posted it, that is the time. Okay, same is for this person. He wants to withdraw his communication, his revocation. He wants to withdraw his acceptance. Okay, what he will do? He will post it again, right? Post it. As soon as he has posted it, it is over. So this point tells us only these two things. Fine. And then this is as against the recipient, this is against the person who is making it. Okay, this will be complete. But against the other person, the same thing is reaching him. That's all. This is reaching him, or this is reaching him, right? As against the recipient when it comes to his knowledge. Okay, fine. So this is it. So I'll just quickly make a 5-minute Hindi summary, okay, to explain this point. तो ये पॉइंट मैं आपको भी बताऊंगा, ठीक है? ये काफी इंपॉर्टेंट पॉइंट, इसलिए मैं थोड़ा टाइम भी दे रहा हूँ इसमें, क्योंकि ये एक बार अगर इस बार आपको समझ गया, ओके, फिर आप कभी नहीं भूलेंगे। इसको लेके क्वेश्चंस आते हैं काफी, इसमें एक डाउट रह जाता है, एक ऐसा पॉइंट है, ग्रे एरिया है, इसमें डाउट रह जाता है स्टूडेंट्स का। इसीलिए मैं ये बता रहा हूँ, इसमें ये टेबल में हमने आपको पूरा समराइज करके दे दिए है कि कैसे होगा ये करके, ठीक है? क्या देखने वाले हम? ये आपको ऑफर साइड है, यानी हम ए बोलते हैं जिसको, करेक्ट? ये ए का साइड है, ठीक है? और ये बी है, एक्सेप्ट कर रहा है जो, ठीक है? तो ए टू बी, यही हम दिखाते थे, करेक्ट? तो सबसे पहले क्या होता है, इसमें दो चीजें होती है। एक है कम्युनिकेशन। कम्युनिकेशन मतलब आपकी बात दूसरे तक पहुंचना, ठीक है? तो आपकी बात पहुंच गई तो इसका ये मतलब नहीं कि कॉन्ट्रैक्ट हो गया, करेक्ट? इसलिए उसी चीज को याद रखना। लेकिन लॉ ये बाइफरकेट करके रखा है कि कम्युनिकेशन कब पूरा हुआ, कब इसके तरफ से कम्युनिकेशन पूरा हुआ, ये सब चीजों को साथ में रख के डिसाइड किया जाता है, ठीक है? तो इसीलिए ये सबको बाइफरकेट किया गया है। फिर हमको याद रखना है कि कम्युनिकेशन का ये मतलब नहीं कि ऑफर कॉन्ट्रैक्ट बन गया। यहाँ सिर्फ ये देख रहे हैं कि आपकी बात मुझ तक पहुंची है कि नहीं, मेरी बात आप तक पहुंची है कि नहीं। तो फर्स्ट जो हमने देखे यहाँ पे, कम्युनिकेशन ऑफ ऑफर एंड एक्सेप्टेंस। ऑफर के वक्त जो है दूसरी पार्टी नहीं, यहीं से इनिशिएट हो रही है, ऑफर के पहले कोई पार्टी नहीं है। ओके, तो इट विल बी कंप्लीट व्हेन इट कम्स टू द नॉलेज ऑफ द एक्सेप्टर, ठीक है? कम्युनिकेशन जो है, इसका ऑफर मैं दे रहा हूं आपको, ये कम्युनिकेशन कब कंप्लीट होगा? जब एक्सेप्टर के नॉलेज में आ जाएगा ये बात, ठीक है। इससे इसके पास आ गया, इसने सुन लिया, तो हो गया कम्युनिकेशन। लेकिन जब एक्सेप्टेंस हो जाता है, इसके बाद एक्सेप्टर के पहले एक पार्टी है ऑलरेडी, इसलिए फ्रॉम पॉइंट ऑफ बोथ ऑफ देम देखना है। ओके, सो फर्स्ट कम्युनिकेशन ऑफ एक्सेप्टेंस इज कंप्लीट एज अगेंस्ट द प्रपोजर एंड एक्सेप्टर, अलग अलग। अगेंस्ट द प्रपोजर कब कंप्लीट होगा? व्हेन इट इज पुट इन अ कोर्स ऑफ ट्रांसमिशन टू बी आउट ऑफ पावर ऑफ द एक्सेप्टर, यानी जो मैंने अभी बताया था, ये इसने इसको कम्युनिकेट कर दिया, इसने बोला ओके, एंड ही हैज पोस्टेड इट इन अ पोस्ट बॉक्स, ठीक है। तो ये इन्होंने एक पोस्ट बॉक्स में पोस्ट कर दिया ये लेटर, ठीक है। तो इट इज कंप्लीट एज अगेंस्ट हिम एंड एज अगेंस्ट द एक्सेप्टर व्हेन इट कम्स टू द नॉलेज ऑफ द प्रपोजर। ये लाइन अब ये आगे जाएगा, ये पोस्ट हो गया, देन पोस्टमैन विल डिलीवर इट, ठीक है। ये जब डिलीवर होगा इनको, इट विल बी कंप्लीट एज अगेंस्ट द एक्सेप्ट, ठीक है। ये दो चीज इसमें देखना है। फिर नेक्स्ट देखे थे हमने रेवोकेशन, ठीक है। कब आप रेवोक कर सकते हैं, टिल व्हेन कैन यू रिवोक एन ऑफर और एक्सेप्टेंस? इसका पॉइंट है ये, यू कैन रिवोक बिफोर दिस, बिफोर कम्युनिकेशन इज कंप्लीट अगेंस्ट द प्रपोजर, यानी he has posted the letter, he has given the letter, ठीक है, he has accepted and posted it back, ये जो पॉइंट है, ठीक है, इस पॉइंट की हम बात कर रहे हैं। ओके, so revoke before communication is complete against the proposer. So basically in short what I am saying is this point, ठीक है, revoke before this point, और इसमें you have to revoke before this point, okay, before the communication reaches the offerer, ठीक है, राइट। तो इसका बहुत इजी है रेवोकेशन का, बस ये एक फर्स्ट पॉइंट है, सेकंड पॉइंट है। अब कम्युनिकेशन ऑफ रेवोकेशन, कम्युनिकेशन ऑफ रेवोकेशन के ऊपर ये देखा जाता है कि दोनों के लिए सेम सेट ऑफ पॉइंट्स है, ठीक है। आपके नोट्स में ये भी रहेगा और ये भी रहेगा, बोथ पॉइंट्स आर एग्जैक्टली अलाइक, ठीक है। सो कम्युनिकेशन ऑफ रेवोकेशन में ये मैंने बोला कि फर्स्ट पॉइंट में वो कब कंप्लीट होगा? अगर ये रेवोक दोनों कर सकते हैं, ऑफरर एंड एक्सेप्टर, सो व्हेन दिस पर्सन इज रेवोकिंग, इसने रेवोकेशन का लेटर पोस्ट कर दिया यहाँ पे, ओके, दिस इज द पोस्ट बॉक्स, यहाँ पे पोस्ट कर दिया, तो ये यहाँ पे कम्युनिकेशन कंप्लीट हो गया इस पॉइंट में, ठीक है। यही ये बोल रहा है, फाइन, ठीक है। दिस पॉइंट उसी की बात कर रहा है, और इसके पॉइंट ऑफ व्यू से भी यही है, सेम फ्रॉम दिस पॉइंट ऑफ व्यू ऑल्सो, ओके। ही वांट्स टू रिवोक हिज एक्सेप्टेंस, पोस्ट कर दिया, और जैसे पोस्ट कर दिया, ओके, तो communication of revocation is completed, okay, and as against the other party recipient when it comes to his knowledge, यानी other party के लिए हम बोलेंगे, okay, against this when he has posted, ये communication of revocation is over, against this person when it comes to his knowledge or when it comes to his knowledge, ठीक है। So this is the explanation of these three main aspects, okay. जैसे मैंने बोला, it is quite confusing for many people. Now let's go ahead. Next point is void agreements, okay. So void agreements, okay. Here there is an acronym, I'll tell you this later. Acronym is nothing but your remembering technique, okay, memory technique, whatever you call it, okay. You can make your own also, okay. So we'll go to that later. Now let's see what are void agreements, okay. These agreements are considered to be void, right? So we have to study all these one by one. One is consideration and objects are unlawful in part, okay. Objects and consideration are unlawful, okay, in part, then the agreement will be void, okay, if any part is unlawful, right? So we are going to examine these in detail, each one, okay. agreements without consideration. So no consideration, no contract. It's a very famous phrase. Agreement in restraint of marriage. So you cannot make any agreement restraining anyone from marrying. Okay, that is a universal right. Okay, you cannot restrain from marriage. You cannot restrain from anyone from doing a trade. Okay, if there is one person who wants to sell something in the roadside, okay, there is another big shop owner, he cannot restrain him from uh, performing his trade. Then agreement in restraint of legal proceedings. Okay, this also we will examine. Then agreements void for uncertainty and agreements by way of wager. Okay, so here basically we are seeing all kinds of void agreements. Okay, we are just trying to examine all void agreements. Now for remembering all these points, you have to remember these sections. Even if you don't remember, it is okay. Okay, even if you don't remember the sections, that is okay. So here, for remembering these things, how to remember these 7 sentences. Okay, that is this acronym for. Okay, so here you can see legal marriage is uncertain. Okay, legal marriage is uncertain and wager trade considered unlawful. Okay, there's no such logic to it as such. Okay, it's just for remembering. Okay, so first is your legal marriage. Okay, so for legal you will have to say this unlawful. Okay, considerations and objects unlawful in part. Marriage, restraint of marriage. Okay, and uncertain, legal marriage is uncertain. Okay, void for uncertainty. And wager trade. Wager is what? Do you know? Any of you know what is a wager? Wager.
Like gambling?
Yeah, it is gambling. Wager means any form of gambling. If you would have seen Pirates of the Caribbean, so in that they use the word wager a lot. Okay, in the second part. So where they play some game. Okay, and there is some reward which is kept. That's called as wager. Okay, so kind of, you can say, kind of lottery kind of thing. Okay, but here you play a game here basically, and normally it is not considered unlawful unless specifically specified. Okay, so it is considered as unlawful otherwise. So here wager trade considered unlawful. So here agreements in restraint of wager, agreements by way of wager, sorry. Okay, wager trade, restraint of trade. Okay, considered consideration. Okay, and this is unlawful in part. This is unlawful, and that legal first was this legal proceedings. Okay, this is how you can just kind of remember it, or you can have your own better method of remembering. That's fine. So these are we are going to consider these now. Okay, the first is considerations and objects unlawful in part. Then the agreement is void. What is this? Okay, if any part of a single consideration for one or more objects, okay, one consideration for more than one objects, and any one or any part, that is one or more parts, they're trying to say, of several considerations for a single object is unlawful, an agreement is void. So what does it mean? It means, okay, first one is one consideration Okay, and you have more than one object. So basically, you have entered into contract of building two houses. Okay, you're building two houses, right? So you have entered into a contract with contractor. Now, one of these, okay, it is legal. It's some legal business you are constructing. Here, this is being constructed for some illegal business. Okay, contractor also knows it is constructing in a way it will aid your illegal business. Okay, so now in this case, so what I'm saying is this is legal. Okay, and this is illegal. Okay, so now if you are giving one consideration, that is whole consideration I am giving him is say 50 lakhs. Okay, then both these contracts are void. Okay, both these are void. Understood? Okay, so here your so what we are trying to say is this is a legal business, correct? This also becomes void. This also becomes void because you have made one payment for illegal and legal together. So that is what this point is saying. If any part of a single consideration for one or more objects, okay, and here in the end is unlawful, the agreement is void. Okay, this is the first part of it, right? Now, second part is this. It says that take the other way around. Okay, if any one or any part of several considerations for a single object, okay, is unlawful. So basically, here, now you give one, here you give one consideration, okay, and you had many purposes. Now, another one is you have same one purpose, let us. You have one person, one purpose. You are building one house only, okay, and it is legal. It's a legal business. You are now paying the contractor, you have to pay him 50 lakhs. Okay. So you have paid him, say, 10 lakhs out of your legal money, 10, 10, 10 legal money. Okay. And then 20 lakhs out of some illegal business of yours. Okay. So, and so these are here, what is happening? You are paying different installments, okay, for the same purpose, one purpose. Purpose is one. Purpose is what? Object. Object is one here. In last one, there were different objects. Consideration was one. Okay. Because this one consideration is void, the whole payment will become void. Void is this illegal. So the whole payment will become illegal. Okay. This is what is the simple explanation of this. You don't have to read that sentence also. Okay. Just remember like that. Like this. One consideration for many objects. One object is illegal, void, whole thing void. Okay. Several consideration for a fair object. But one consideration is illegal, whole thing is void. Okay. That's what it means. So here you can see an example here. Okay. Here A promises to inspect on behalf of B, okay, a legal manufacturer of indigo. Okay, so basically B is asking A to inspect, is giving a job of inspector to A. Okay, A promises to inspect on behalf of B. Right, so study very closely. You should know who is the employer, who is the employee. Okay, whenever it is in passive, as in this case, sometimes you might get it wrong. So A promises to inspect on behalf of B, a legal manufacturer of indigo and an illegal traffic in other articles, and pays 1/10,000. Correct? Agreement is void as consideration is partly unlawful. Okay. Fine. Got it? So this is what is the first one here. Consideration and object unlawful in part. You can just write in your own words. Don't even have to learn this. Just learn these things, these main sentences. By the time I would have explained all this, you can just write everything in your own words. Okay, fine. So this is one. Second is agreements without consideration. Correct? Yeah, agreements without consideration. Now, consideration is required for all commercial contracts. Okay. If there is any contract, okay, so there has to be a consideration. Okay. If there is no consideration, why would someone give a valuable thing to another in the course of his business? Correct. So, which is why law says that agreement without consideration is void. Okay. So here, so just remember always, agreement without consideration is void. So we will see when we go ahead. There is another phrase called no consideration, no contract. Okay, it's asked also several times. No consideration, no contract. Okay, explain. So we'll see this. Okay, fine. So now, so agreement without consideration is void. That's what we have seen here. So this is good for everything, but there are some exceptions. Okay? Now it is void unless. That is, we are seeing what are the exceptions. Okay, fine. So we are just seeing what are the exceptions. Okay. So here, first exception is, so general rule is what? If there is no consideration, then no contract. Okay, no consideration, no contract. But it will be treated as a contract if, okay, it will be treated as a contract if one is it is in writing and is registered. Writing and registered, just see the colored part. Okay, it is writing and registered. Even once if you just read it, it is fine, but later on you can just in your notes go through the colored parts. It will make full sense to you. Okay, so it is in writing and registered and made on account of natural love and affection. Okay, in that case it is a contract. For example, okay, your dad says that if you pass with this much percent marks, okay, I will buy you a car. And he has registered this agreement. If we registered it, so it should be in writing and registered. That is a condition and made on account of natural love and affection. Okay, then it is a contract. It is enforceable. Even though you have not given any consideration to your dad, right? Still it is a contract. Okay, so this part is definitely for parties standing in near relation to one another. So in this case, even if there is no contract, it will be a, even if there is no consideration, will be treated as a contract. Okay, and then next is, okay, promise to compensate something done, okay, already voluntarily. Okay, so if someone has already done something for you, right, already done something for the promiser or was legally compellable to do, it means that if some person has done something good for you already, okay, say for example in your earlier years, okay, in your earlier years some person has say helped you in some way, okay, and later on when you have become someone with good means, okay, later on, okay, you have become rich after 10 years or so, and now you want to give him something because you still remember that something good was done in the past, okay, but after 10 years it will appear as if you are unilaterally giving him something. There is no consideration, but consideration was in the past. You're getting it? Consideration was there in the past, but right now there is no document or something to prove that consideration, correct? It is appearing as if you are uh, you are yourself unilaterally giving something. Okay, it will appear like that. So but in this case it will be treated as a contract. Okay, you just have to, even if you can prove that something was done, and then you are ready to compensate something. Okay, just a moment. Allen says, but there's already a provision, it's not enforceable because of social relationship. Okay, so this sometimes in law what happens, there are certain things which become enforceable. Okay, so here you have an express provision. General provision is social contracts are not contract, but here expressly law is saying that this is okay. Okay, in everything there'll be some exception or the other. So here in this case, it has been given specifically. This is specifically, normally this will happen. This will be like a social thing. Okay, this will be more of a social thing, but this will be a contract. The son can claim it from the father if he has made it in writing and registered it. Okay. So if there is any express provision, it will, in law, general rule is that an express provision will always override the general provision. Okay. Overrides general provision. Okay. Okay. So now, so this is no first exception we have seen. Second exception we have seen that uh, it's a promise to compensate. Someone has done something already and you are recognizing it. Okay, and you are recognizing it and you are promising that no, you have done this thing to me, I will pay you. If I have the means, I will pay you this much in future, whatever is the future. Okay, in that case that will be considered as a contract. Okay. So these both what we have seen is agreement without consideration. Here there is consideration, but it is not visible clearly. You see, this might come up say after 10 years or so. Okay, you might give him a contract later on after 10 years. He might encash it 5 years after that. Okay. So which is why here, although there is consideration, but it is invisible. And then last exception to no consideration, no contract is promise to pay a time barred debt. That is debt by limitation law. Okay. So have you heard of limitation law? Any one of you? Law of limitation. Okay. In law of limitation, what happens is, now when a case is settled, okay, there is a time. Okay, there is a time within which you can challenge it. Okay, let's say it's 3 years or 5 years. So for different things, there are different terms like that, which is stated by the law of limitation. So it's the Limitation Act. It is an act. Okay, this taught in CS, not there in your course. Okay, so this law of limitation. So otherwise, what will happen is if you give him time to challenge it, then the other person, okay, he can never be at peace, right? He knows that after 10 years he can challenge me. After 25 years, when I'm dying, that time he can challenge me, right? So that is why law has given a time, a limitation, that if you want to challenge, you challenge within this time. This period is different for different types of agreements. Okay, the periods only are defined in the Limitation Act. Okay, so if that time is gone. Okay, it's called a time barred debt. Okay, if say like if 3 years was the time and now 3 years have been crossed, so it becomes a time barred debt. So now you do not have the right to raise it in a court of law beyond that period. Okay, so third is it's a promise to pay a debt barred by limitation law. And here what is being said is it's a promise made in writing. Okay, so normally what will happen if the it's a promise to pay a debt barred by limitation law, okay, then the other person will not be able to sue him beyond the limitation period. Okay, right? But here what happens, this is an exception to this point. Okay, so here he will be able to challenge beyond the limitation period also. This is basically for commercial contracts. If limitation law is applied to all commercial contracts, then many people will end up in a loss, correct? Right? In commercial transactions, many transactions happen after 5 years, 8 years, like for long-standing transactions. So that's why if it is a promise made in writing, signed by the person to be charged or his agent, your debtor basically, signed by the debtor, is promising the writing in writing to pay a debt, okay, of which creditor might have enforced payment, but for the law of limitation. Okay, he has a promise in writing that I will pay you this debt within 5 years if he has promised it, and the limitation ends in 3 years. Okay, so still that promise will hold good for 5 years. Okay, for commercial contracts. Okay, this is done for basically for to protect commercial contracts. Right, now you will ask me, how is this agreement without consideration? Why is it agreement without consideration? There would be agreement here, right? There would be a consideration. Only then there is a credit, correct? Okay. Why it is agreement without consideration is after the period of 3 years. Okay. Let's take 3 years as the example of limitation. So after 3 years, anything it can be 5, 10, 8. Okay. After 3 years, as per limitation law, okay, there is now no debt. Limitation law says after the limitation period, there will be reset. The parties will be reset to zero. There is no transaction now. Neither he has to pay him anything, nor does the other has to pay him this. Once it is reset, okay, now if this person, the person was made promise, okay, he is paying him, he's saying I'll pay after 5 years, say he's paying 50,000. Now he's paying 50,000 for what? There is no transaction, right? It has been reset after 3 years. So it appears as if it is a contract without consideration. Okay, so it is okay. Understood? Okay, these are agreements without consideration, right? So I'll give you a break after at 7:30, 10 minutes break. Okay, rejoin at 7:40 and we'll continue till 9. Okay, so now, so here these we have done, and then in any of the above cases, agreement is a contract. Okay, all these three are exceptions. Now, following won't be void. This won't be void. Okay, without consideration also, it is not void. Gift. If you are making a gift, it is okay. Fine. So, gift actually made, or second is if the consent of the promisor is freely given. Okay, agreement is not void if it is inadequate. So, less consideration doesn't make it void. Okay, so if say I have a bike and the value is 1 lakh, you are my friend, I am giving you for 20,000. Okay, that doesn't make the contract void. Okay, so as per the contract act, inadequate consideration is okay. What did we say? If you carefully see the sentence, no consideration, no contract. Did we say less consideration, no contract? No, right? It is no consideration. So if it's zero consideration, only then it applies. So following won't be void. What one is gift actually made? Gift is okay. Contract will not be void. And if consent is given, consent is freely given, then inadequate consideration is okay. Why is the word freely given? Is there should be no coercion. Coercion means use of force. Okay, you are giving him, if there is some goon or gunda. Okay, he is asking your bike for 20,000, and out of fear you are giving it. Then it is not a contract. Okay, so consent should be freely given. Okay, so agreement is not void, but there's one thing, that inadequacy of consideration can be used by court for determining whether consent was free, okay, or it was forced by coercion or means like that. Okay, fine. Right. So now here we have got some examples. Okay, the points we have studied. A promises for no consideration to give B rupees 1,000. Okay, that's a void agreement. Agree. Wherever you disagree, just let me know or ping me. Okay. A promises for no consideration to give B rupees 1,000. This is a void agreement. Okay. Why? Because there is no consideration. No consideration, no contract. Okay. Now, let's see the next one. A finds B's purse and gives it to him. Okay. B promises to give A 50. This is a contract. He has done something for him, right? Has found his purse. So it is a contract. Okay. Then next is A owes B rupees 1,000, but the debt is barred by Limitation Act. A signs a written promise to pay 500 on account of the debt. This is a contract. Okay. Limitation point which I explained. Right. So it can be like he can, it's not necessary always he'll sign for a less amount. Okay. So the main point is like after the Limitation Act, if he is signing something that he will unilaterally give, that is a contract. He can undertake it before the limitation period or after also. Okay? That's not a problem. Achha, next is A agrees to sell a horse worth 1,000 for 10. Inadequate consideration. So A's consent was freely given. That is a contract. Just now we saw that. Now the same example, A agrees to sell a horse worth 1,000 for 10, same. Then A denies that his consent was freely given. He says that I did not give my consent. Okay, he just forced me to sign it. Okay, then court will check whether it was freely given or not. It is proved that consent was not freely given, then it will be, the contract will become void. Done? Okay, good. All good. Next is no consideration, no contract points we are saying. Sorry, uh, the void contracts. Which contracts are void? Those points we are doing. Okay. Next is an agreement in restraint of trade is void. Okay. So you cannot restrain anyone from marrying. Okay. So it is void. Cannot restrain any major from marrying. Okay. It does not apply to minors because marriage of minors is illegal as per the general law. Okay, it's already illegal. Okay, so that's why this doesn't apply to general laws. General law is up, mercantile law is below the general law. Okay, in terms of priority. When mercantile law has already made it illegal, so when general law has already made it illegal, mercantile law doesn't have to do anything here. So it doesn't apply to minors. Okay, so we are talking about majors here. Okay, if adult agrees for some consideration not to marry, it is a void agreement. Like in movies and all, this show, right, that say the dad of the heroine, he gives some money to the hero, right? These things are shown. He says, don't, should not marry my daughter. Okay. So actually, if proved, that is an illegal thing. Okay. Fine. So this is basically an agreement in restraint of marriage is void. Okay. Agreement in restraint of marriage is void. Next is agreement in restraint of trade. So like marriage, you cannot stop anyone from any lawful work. Okay. So any agreement restraining a person from exercising a lawful profession, trade, or business. Okay. You cannot, even a poor man who is just selling, say, fruits. Okay. Is just selling fruits in a thela or whatever. Okay. He's just carrying in a bag some fruits and selling. And opposite it, you have got a big Reliance Fresh uh, shop for vegetables and all that. Okay. So they cannot stop him from exercising his trade. Okay. So everyone has a right to trade. Right. So you cannot restrain from exercising a lawful profession, trade, or business. There is one exception to this agreement: not to carry on business of which goodwill is sold. Okay. So I had given one example, I think no, not in this class. Okay, here, see. So why it is that if you sell goodwill, okay, so I said that agreement in restraint of trade is void. Okay. But agreement not to carry on business of which you have sold your goodwill. Okay. So for that, it is not void. Okay, you can restrain him. So reason is, say for example, there is one Dr. Mishra. Okay, you have a Dr. Mishra and he runs Mishra Hospital. Okay, Dr. Mishra runs Mishra Hospital. He is a very famous doctor in an area. Okay, now a new doctor comes to buy his business. Okay, so new doctor comes, okay, to buy his business, and that new doctor, okay, pays him some money, whatever, for the clinic and all, pays him an additional, so pays him 20 lakhs in general, okay, for the whatever clinic and whatever the place and all that, 20 lakhs. In addition to that, he's paying him 30 lakhs. Okay, he's paying 30 lakhs for goodwill. Right. So why 30 lakhs? Goodwill, you all know, like commercially, because of the name of this person, Dr. Mishra. Okay. And there are so many people who come to his clinic. Let's say weekly, he has a practice of 500 patients. Okay. So now these patients will come to this new doctor, right? So because his clinic is well placed and he has some name, whatever. Okay. So now, even if not all, but most will come to the new doctor. Okay. So that additional revenue which he is getting, that he'll pay to Dr. Mishra as goodwill. Correct. So now let us think that, okay, so this doctor is covering, let us say, an area of 5 square kilometer. Okay, is covering an area of 5 square kilometer. Okay, normally one clinic will cover a certain area, right? So then other locality people will go to some other clinic, right? Now, so this is area of, say, is covering an area of 5 square kilometer. Now you tell me, so he has sold it now for 50 lakhs, 30 plus 20 lakhs, right? 30 plus 20 lakhs, 50 lakhs he has sold it for. Now, if Dr. Mishra, after selling next day, is just coming to and starting clinic next door. Okay, wherever his clinic is, just next door he has got a place and he's starting. So won't the people here, these 500 patients, won't they go back to Dr. Mishra? Correct. So then 330 lakhs which he has taken for goodwill, that will become a wrong collection, correct? So isn't it getting the point, right? So which is why when goodwill is sold, then he can be restrained from having business in this area of 5 square kilometers. Okay. Only then these people will come to the other doctor. Okay. I hope you got this point. So which is why agreement not to carry on a business of which goodwill is sold. Okay. So this is an exception to agreement in restraint of trade. So here you are restraining Dr. Mishra from not practicing in 5 square kilometers, but it is not void. Okay. Okay. One who sells goodwill of a business may agree with the buyer to refrain from carrying on similar business, okay, in within specified local limits, as long as the buyer carries on like business. Okay. He can start some other business, that is fine, which is not a competing business. Okay. Right. So if he has sold the clinic and he wants to open a medical stores there, that he can do. Okay. So then provided that limits appear to the court reasonable. So that is the limits, the 5 square kilometer which I was talking about. Okay. You cannot say that no, you cannot practice in this city. That is unreasonable. That courts will not allow. Okay. So it should be like whatever goodwill you have sold, at whatever goodwill, whatever is going to affect that clinic, only that much area you can restrain him. Fine. The next is agreement in restraint of legal proceedings. Similarly, you cannot have a agreement with someone saying, see, this is what is the deal, but one more contract you have to sign that whatever will happen in future, you will not sue me in the court. Okay, you will not take me to the court. Such agreement no one can make. Okay, it is void. Okay, so if you are restricting absolutely, just go with the colored words have been made so you can study very quickly. Okay, if anyone is restricted absolutely, okay, from enforcing his rights under usual legal proceedings, okay, that you cannot, in short, it means that you cannot take me to court, right? Or this is one thing, you are saying you cannot take me to court, or even if you are limiting the time, you are saying that, see, if you have quit my job for the next 1 year, you cannot sue us. After that, you can do anything, but for 1 year, you cannot sue us. Even that you cannot. Okay, you cannot even limit the time. Okay, so agreements in restraint of legal proceedings are agreements which is restricting absolutely from going for legal proceedings or limiting the time or extinguishes the rights of any party, discharges any party thereto. Okay, you're extinguishing the right of any party, or you're taking away rights, such rights you are taking, and your intention is to restrict him from enforcing his rights. How this can happen? How you can discharge a party or extinguish his rights to restrict him from enforcing his rights. So basically, so in certain cases, say you have uh, a director. Okay, you have a director, right? And he has a certain number of shares. Okay, now for going to say to complain against your company, okay, he needs a certain number of shares. Okay, many times we have provisions that these many people or these many shareholders can go for certain things. Okay, so if say you are firing the director, okay, you are firing him, and so that he should not take action against you, what you are doing is you are forfeiting his 1,000 shares. Okay, you are giving money to him, compensation you are giving, but you are forfeiting his shares. Why? because if shares are there, then he can go against you. Okay, either legally or in whichever way. Okay, so if you are doing something, okay, so actually speaking, here you have given him his money, right? Why are you forfeiting the shares? For no reason, so that he should not be able to take any proceedings against you. Okay, if that is the intention behind it, okay, then it will be treated as agreement in restraint of legal proceedings. Okay, right? So there are two things here in restraint of legal proceeding. One is absolute restriction. Secondly, you are extinguishing his rights, which is causing restraint of legal proceeding. Okay, exceptions. So uh, you are restraining from legal proceedings, but it is not void. These are the exceptions. Okay, first is saving of contract to refer to arbitration dispute that may arise. Okay, so do you know about arbitration tribunal? Any of you? Arbitration, what you have heard? Conciliation. There's an act called Arbitration and Conciliation Act. Okay, so there are many. See, these are your legal courts and all are there. Okay, now arbitration is kind of a smaller court. Okay, so it's not a court officially. Okay, what in arbitration, there are some people say who have either retired from the courts, retired judges, people like them, they run an arbitration tribunal. Okay, so in arbitration tribunal, what happens is normally businessmen, if they have any dispute, they go to the arbitration courts. It gets resolved quickly. Okay, anything which is more of a private nature, for that conciliation is done. Otherwise, arbitration. Okay, for business related matters, arbitration. So here, if anyone has agreed, some businessmen, they agree that all our disputes will take to this arbitration council. So if you have agreed it, you cannot go to the court. Okay, so courts watch over arbitration tribunals. Okay, but because in business parlance there are so many disputes that courts will be flooded with cases, so which is why they prefer arbitration tribunals. Okay, you can just say that these are just small kinds of courts, okay, with similar powers. Okay, they are not courts. Okay, so this is, so if you are writing that all we will refer only to arbitration, then it will not be considered as agreements restraining legal proceedings. Okay, and that only amounts awarded in such arbitration shall be recoverable. That is okay, right? So first point was what? Saving of contract to refer to arbitration. So referring to arbitration, you can say. Okay, stating that we will only go to arbitration. Basically, this means we will only go to arbitration tribunal and nowhere else. Okay, this is okay. Okay, and then this one, saving of contract to refer arbitration questions that have already arisen. Okay, this is also refer same as your first point. So you can also say that whatever in the past arbitration has decided, if that point comes up again, that dispute comes up again, we will only go to arbitration tribunal. That is okay. Okay. Next is saving of guarantee agreement in writing of a bank or financial institution. Okay, saving of a guarantee agreement in writing of a bank or financial institution. Okay, what this says is, okay, guarantee agreement. So banks many times they enter into guarantee agreement, they give guarantees. Okay, guarantee means if a party defaults, then they will pay for it, like that. Okay, right? So that is called guarantee agreement. So here, making a provision for extinguishment of the rights or discharge of any party from any liability. Okay, so you are making a provision for extinguishment of rights or discharge of any party from liability. Okay, on the expiry of a specified period, which is not less than 1 year. Okay, now this is the main point, from the date of occurring or non-occurring of a specified event. Okay, so what happens here is in banks, when banks enter into guarantee agreement, okay, so you can, what they can do is in guarantee agreement, they can say that they'll put some conditions that I'm giving you a guarantee. Say they'll put some conditions. If you do not follow, okay, 1, 2, 3, whatever, okay, if you do not follow, then we will withdraw the guarantee. Okay, withdraw the guarantee. Okay, now guarantee is a commitment, a contract. Okay, so here a contract where they are withdrawing from guarantee. Okay, if they are withdrawing from guarantee, if it is as per stipulation, then these people cannot go to the court against. Okay, because this bank's regular work where they give guarantee, right? So this has to be regularized. So if bank withdraws guarantee as per the stipulations, okay, then it should not come as restraint. Okay, and bank is giving a stipulation, you cannot go to the court if I am withdrawing guarantee as per these stipulations. And if it is doing as per these stipulations, then they cannot go. If it is not as per stipulations, then they can go. Okay. So this is your guarantee agreement, saving of guarantee agreement in writing of a bank or financial institutions. Okay. So these are the three things which we have seen here for exceptions of, okay, agreements in restraint of legal proceedings. Okay, these are the exceptions. Arbitration tribunal, first 2 points are that. Last is guarantee agreement of bank or financial institution. Write in your words. Okay, need not use this complex this thing. Just write in your words the way I have explained. Okay, and actually for these points you just have to write the point. You don't even have to explain it. Okay, it depends on the weightage of the question. So normally these questions will come only where you have to write just 1 or 2 points of these things. Fine. Chali. So now all these things have happened. And next is agreements void for uncertainty. Okay. Which agreements are void? We are continuing with that. Agreements void for uncertainty. Okay. So agreements, the meaning of which is not certain or capable of being made certain. Okay, there are some examples. We can quickly see these. So A agrees to sell B 100 tons of oil. Now he is not showing what kind of oil. 100 tons of oil can be kerosene oil, can be cooking oil, correct? Anything. Some oils can be very costly, some can be very cheap. So it is void for uncertainty. Okay. Then next is A agrees to sell B 100 tons of oil of specific description known as an article of commerce. Okay. So its description is known like you are saying, for example, any rice brand, take, or say atta, like Ashirvad atta or something. Okay. So like that. So it is not, there is no uncertainty. So it is not void. Okay. If you are specifying what kind of thing you want, okay, then it is fine. Then A agrees to sell B 1000 kg of rice at a price to be fixed by C. Sometimes you have some valuers who fix the price. Okay, as the price can be made certain, there is no uncertainty. Okay, you can have a contract such that the price is fixed by someone else. Okay, A agrees to sell B my white horse for 500 or 1000. Now this cannot happen, right? You cannot say 500 or 1000. That is void. Void for uncertainty. So uncertainty is something where whatever is written is not specific. Okay, it's not clear. That becomes void for uncertainty. Okay, fine. So okay, next is agreement. This is the last one. Agreement by way of wager is void. Okay, so kind things like betting, gambling. Okay, these are called as wager. So in when you are doing wager, wager is illegal. As I said, generally they are illegal. Some specific things can be made specifically legal. Okay, generally they are illegal. So if you are so because wager contract is illegal, if you have won anything on wager, okay, or two people are gambling, there's a third person, whatever a person is winning, he's giving to that person. Okay, you keep, I am winning. In the end, I will take it. In the end, he runs away with that money. Now, this person cannot go to court. Okay. So agreement by way of wager is void means you cannot go to court for it. So anywhere and if anyone related to that wager, if anyone is defrauding anyone else, there is nothing you can do legally. Okay. So the wager is basically your kind of some card game or something like that where you are uh, earning money illegally, which is not allowed by law. Here, one thing you have to understand: certain types of horse racing are not illegal. Okay, so there are some horse races where people contribute for a plate. Okay, and the winner gets that plate. Okay, things like that are not illegal because you are racing. That's something which is manual skill, right? Racing of horses, and then so whoever is winning, he is getting the prize. Okay, so if it is not illegal, they will tell you in the problem that it is not illegal. Okay, so you might not know which type of horse racing is legal, which is illegal. Correct? Even I don't know various types of horse races. Okay, so because that's not our specialization, right? We don't know the kinds of horse racing and all that. So they will tell you that it is lawful or unlawful. Okay, so certain prices of horse racing is not unlawful. Okay, so then any sum of money of 500 or more to be awarded to the winner, that is fine. Okay, so that is not that will not be considered as illegal. Then next thing is it doesn't legalize any transaction connected with horse racing to which 294A of IPC applies. Okay, what is IPC? Anybody knows?
Indian Penal Code.
Very good. Okay, it is Indian Penal Code. Okay, so in Indian Penal Code, basically what is written is anything which the law considers as things which are punishable. Okay, what are the punishable things as per our Indian law? Okay, that comes under Indian Penal Code. So police basically will take action only if it is not correct as per the Indian Penal Code. If you have not done, if you have done something which is not punishable as per IPC, okay, police cannot take action. Okay, so what is being said here is if there can be some horse racings, okay, to which IPC, Indian Penal Code, applies to it, okay, then that will not be legal. So in Indian Penal Code, only those things will be there which are punishable as per our law. Okay, that's what it means. Fine. So we'll come back and we'll talk about consideration now. Okay, so you can now go for a break. Okay, come back at 9:45. Okay, it's 9, sorry, it is 7:33 now. Okay, and come back at 45. Okay, 7:45 basically. Okay, fine. Be back at 7:45. You can stay back if you want in this, or you can go out and join back. Fine. Okay, anything you can do. Okay, so welcome back. We'll continue now. Right. So now we're going to talk about consideration. Okay. So consideration is something. Okay. See, A and B. There are two parties. Okay. So A wants what? Say A wants 100 kg rice. Okay. At let's say 120 per kg. Okay, A wants this, and B is a rice trader. Okay, so if the deal is fixed, so A is now giving B 120 per kg into 100 will be 12,000. Okay, rupees 12,000 A will be giving to B. Okay, what will B give to A? He'll give him now this 100 kg of rice. Okay, this is what is with B. So basically what is going to happen here is A will give B 12,000 rupees and B will give A 100 kg of rice. Okay. So what is consideration is whatever you are getting in return. Okay. So basically you are in a contract, you are giving something, you are taking something. Correct. So what you are taking or what you are getting in return, that is your consideration. Okay. So consideration for B is rupees 12,000. Okay. And consideration for A is 100 kg of rice. Okay. So consideration is what that person gets in return. Okay. Generally, what we do is like we just say consideration is rupees 12,000. Okay. Because by money, you can put a value to the 100 kg rice. Okay. It becomes measurable. So you just say that consideration is 12,000, but it is consideration in monetary value is 10,000. Okay. When you talk about only consideration, right? Consideration for B is 12,000, for A is 100 kg of rice. Okay. Just think what they are getting in return. That is their consideration. Okay. So now if we go by the definition, when at the desire of the promisor. Okay. So promisor is making that offer, right? So when at his desire, the promisee or any other person, when at the desire of the promisor, the promisee or any other person, okay? And there are three things: has done, does, or promises to do. Past, present, future. Has done, does, or promises to do. So when at the desire of the promisor, okay, if there is no desire of the promisor, then it will become coercion, right? Without desire, if you are making someone enter into a contract, then you are forcing him, which is illegal. Okay. So desire is essential. So when at the desire of the promisor, the promisee or any other person has done, does, or promises to do. Past, present, future. Something. Okay. It's done, does, or promises to do something. Okay. Then such act or abstinence or promise is called consideration for the promise. Okay. When at the desire of the promisor, promisee, okay, has done, does, or something to, or promises to do something, then such act or abstinence or promise is called consideration for the promise. Okay. This is how it is decided. Abstinence is uh, not doing something. Okay. You can, the contract can be for a positive act, negative act. Okay. I gave you the example of Reynolds and, okay, Reynolds and Rotomac. Okay. If Rotomac wants to enter the same business in the same area, and it is giving Reynolds that, okay, I will not come in this area, you give me a compensation of 10 lakh rupees. This is consideration for not doing anything. Okay, that is called as abstinence, not doing. Okay, so this is the definition. So definition basically talks about what the promisee is going to do. Okay, that is called his consideration for the promise. Similarly, promiser will also have a consideration. Okay, similarly, promisee will also have a consideration. Okay, promiser's consideration will be say whatever the rise or whatever the promiser is giving. Okay, and promisee's consideration will be the money that the promiser will be giving. Okay, now both parties can be interchanged. It's possible that the promiser is the trader and promisee is the buyer. That's also possible. So consideration is essential for every contract. Now, fundamental principles of consideration. So this fundamental principles, it comes from this definition only. Okay, it's a desire of the promiser. Okay, so consideration must be at the desire of the promiser. Okay, it may move from promisee or any other person. Okay, it may move from the promisee or any other person. Sometimes it happens that we go to a shop. Okay, sometimes say you've gone to a shop. Okay, so you've gone to the shop, you have bought 5 kg rice. So, and then this is the shopkeeper. Okay, fine. This is the shopkeeper. You are telling the shopkeeper, you give the rice, he has given the rice, and the price is 500 rupees. Okay, price is 500 rupees. Now you are saying, you give me your number, I will ask my whatever dad, mom, husband, wife, whoever, okay, to transfer it to you. Correct? It happens many times. You go to shops and all, you don't have money sometimes. Okay, you just call someone and ask them to transfer. Correct? It happens sometimes. So in this case, are you paying the consideration? It's the third party who is paying the consideration, correct? Third person is paying the consideration. Right? So if you were the shopkeeper, what will you say? Will you say that you give me the consideration, otherwise I will not take it from the third person? Will you say like that? No, right? So just remember that consideration, okay, can move from a third person. Okay, so consideration can move from anyone else. Anyone else can pay it, but it must be at the desire of the promiser. His desire is to buy this 5 kg rice, and he is asking the third person to pay. So it should be at the desire of this. It should start with the desire of the promiser. It can move from a third person. So this particular thing, no, which I have told you now, it is a part of a famous case law. Okay, which was Chinnaya versus Ramaya. Okay, Chinnaya versus Ramaya. So in this, what happened is there was an old lady. Okay, in this case, it was established that consideration can move from the promisee or any other person. Okay, it was established in this case. So here, old lady, by a gift deed, she made a gift deed of a property to her daughter. But she said that I'm giving you the property. Okay, but she had a brother. Okay, old lady had a brother. So she asked her daughter to pay annuity to him. Okay, to her brother or brothers. Okay, whatever. Annuity means annual amount just for maintenance. So basically, you can say what the old lady did is, okay, here is the old lady. Okay, here is her daughter. The old lady is saying, I will give you 50 lakhs property. Okay, but I have a brother. Okay, okay, so his uncle, so probably he might have needed maintenance, whatever it is. Okay, he said you should give him, say, yearly give him 50,000 rupees every year. Okay, let's say, I mean, the old lady herself was old, so he's also old. So say he is there for, let's say, 10 years. So about 5 lakhs she has to pay, let us say. Okay, in total. Okay, considering he'll be there for 5 years. And she's getting, the old lady gave her 50 lakhs. So basically, what the old lady is saying is, she gave her 50 lakhs and she's saying, out of 50 lakhs, give 10 lakhs, 5 lakhs to my brother. Okay, in yearly installments, you can give 50,000. Okay, so now the old lady died after this. After saying this, she died. The deed was made. Now the daughter did not pay, and daughter said that I will not give him anything because this consideration of 50 lakhs moved from my mother. This did not move from my uncle. Brother of old lady was his uncle, right? It did not move from the brother consideration. So which is why I do not have to pay him. Then court said that it is not necessary that consideration should move from the main party. It can move from a third party also. Okay, so this was the case by which they said that consideration from old lady 50 lakhs was sufficient consideration. Now you have to honor the contract and give him annual 5 lakhs. So what she was saying is, see, I have no agreement with this person, so I will not give anything. Okay, there is no consideration between him and me. So that was struck down in this case. So she had to pay annuity to the donor's brother. Daughter agreed in writing but declined to pay in the future. Okay, declined in the future. Held uncle could sue. Okay, the consideration from mother was sufficient consideration. Okay, fine. So now types of consideration. Okay, this is very simple. Past, present, or future. Consideration can be past, present, or future. Right. So say if you are the offerer, right? So you can get a consideration which is past, present, or future. Okay. There are two parties, right? So here, from the point of view of one party, so it can be executory. Executory means future consideration. That is, you have performed your part. Okay. So, for example, you have paid for the rice. The shopkeeper will deliver after 2 days. Okay. So, basically, your consideration is executory or future consideration. Shopkeeper's consideration is present. Okay. So then present, so example for future consideration is A makes an engagement with B to marry her in future. In this case, both of their considerations, the engagement, okay, right? So again, you might argue that uh, this is a social agreement. Okay, you might argue that this is a social agreement, but it's just for the sake of explaining to you. Okay, A makes an engagement to marry her in future, right? So see, in this case, why sometimes it becomes admissible is if you are making an engagement, okay, And for engagement, let us say they have given the other party some money, whatever. Okay. So, and then the engagement has been broken, then the first person is bound to give back the money, right? It becomes a legally admissible case. Okay. So in cases of marriage and all, okay, in future there can always be an admissible case. So here, so first of all, this is executory or future when consideration is going to come in future. Okay. Present is uh, it is current. Okay. Act or forbearance made or suffered for a promise. Okay. And here also, as you can see in executory and future, here, because there are say two parties, as I said, it is very much possible that one party has given a present consideration, another party is going to give a future consideration. Correct? It's possible. You have paid the amount, but he will give it in the future. Okay. Or he has delivered the goods, which many times happens, and you will pay in the future. Right? So basically, executory or future promise to be performed in future. Okay. So this is called as executory consideration. Present is it is given just now. In the present, you have given it. It's called as executed. I have given it. Past is you have already given it. Okay. The other party has not yet performed this consideration. It means past act or forbearance. Okay. Forbearance is something again, as the name suggests, B-E-A-R. You are bearing something, right? That is like abstinence. Okay. In abstinence, uh, you are not doing something, but here in forbearance, you are bearing something. So say you are saying that okay, I will not raise an issue for 6 months. Okay. So someone is there, he's saying I'm constructing my road till that time. Let me use your pathway. And for that, he is giving a money. So that is payment for forbearance. You are bearing something. Okay. It's all the same thing basically. Abstinence and forbearance are close. Abstinence is you are saying, I will not do it, and for that you are getting money. Forbearance is you are bearing something, for that you are getting compensation or money. Okay. So past means which is done in the past. One party has done it and he has not yet received the payment. Okay. He has done it and the promise. Okay. Uh, after that, after doing it, they have entered into a contract. Okay. So this becomes past. Three types of consideration are there. Just remember it as it is. That's it. It is like types of consideration. If it is asked, it will be like 4 marks or something. You just have to write little bit links. That's all. Okay. So this is your types of consideration. Next, we are going to talk about legal rules regarding consideration. This is something which more or less we have already studied. Okay. So first one is it must move at the desire of the promisor. Okay. It must move at the desire of the promisor. It may move from promisee or any other person that we have seen. Consideration must be of some value. It must have some value. Okay. It may be an act, abstinence, forbearance, or return promise. Okay. Then it may be past, present, or future, which the promisor is already not bound to do. Now, what we are saying is which promisor is not already bound to do, it means that why it is specifying that is, say earlier, there's a person A and a person B. Okay. So now A has given B a car. Okay. And a value which he had to pay second-hand car, let us say, for 2 lakhs. Okay. B has taken the car and he has not yet paid this. Then after 6 months, they have entered into another contract after 6 months. Okay. Where A is giving B something, let us say, A is giving B something worth 2 lakhs. Okay, some goods worth 2 lakhs. So now B is giving him 2 lakhs. Okay. Actually, this 2 lakhs is for his earlier transaction of car, but he is showing as if he is giving it now. So this, for this point, they are saying consideration should not be already what the other person is already bound to give. Okay, that's why they are saying it may be past, present, or future, which the promisor is not already bound to do. Okay, that's why they have used it. Must not be unlawful, need not be adequate. We have seen inadequate consideration is fine. Okay, must not be illusory. Illusory means imaginary, something which is not going to happen. Okay, cannot give a consideration which is not going to happen. Okay, you cannot say make a contract saying I'll give you 20,000 rupees when the fairy gives it to me. Okay, there's no fairy, she's not going to give it to you, right? That's an illusory consideration. It should not be illusory, imaginary. Okay, it must not be opposed to public policy. Okay, it must not be opposed to public policy means it must not be illegal, right? Then pre-existing obligation. So pre-existing obligation is similar to here what we have seen, is not already bound to do so. Okay, so these are legal rules regarding consideration. Very simple, you can just remember it. I don't think you need anything to remember this. Okay, so you can just remember it easily. Fine. So 10 points in all. Okay, legal rules regarding consideration. Fine, just remember it. These are all important questions and you can remember it easily also. Fine, so just remember it. Okay, so then next is no consideration, no contract. I was telling you this, right? No consideration, no contract. So this is a Latin phrase here. Okay, ex nudo pacto non oritur action. The name is ex nudo pacto non oritur action. In contract act, you hardly have 5 or 6 kind of these Latin phrases. Sometimes in your fill in the blanks or something, it can come. You just have to choose what in fill in the blanks. You'll get it in multiple choice questions. So you should just be able to tell what is the meaning. So you exactly don't have to learn it. So in all these sentences, there is one word you can pick it up. Okay. So that separate word, distinct word you will get in all these Latins. So by the time we'll complete entire law, you will hardly have, I think, 8 to 10 Latins. That's all, not more than that. And everything will have this. Here there is something called nudo facto. Just remember this much. Any one specific word which I will tell you. Okay. As I now, this is the first one you are seeing. So as I now we go ahead, I'll just tell you that. Just remember it. As such, you don't have to learn this entire thing. Okay. Any specific word. For example, orator. Orator is there here. It will not be there in others. Like that, you can remember. This word is there. It means agreement without consideration. Okay. Fine. So agreement without consideration is void. Okay. So this is no consideration, no contract. Exceptions, this we have already studied. Promise made on account of natural love and affection. Promise to compensate for voluntary services. Okay. So this is again voluntarily someone has done and you want to give something back, correct? That one. So these are exceptions where no consideration, no contract does not hold good. Promise made for a time barred debt, correct? This also we have seen. It is also not void in case of, okay, it's not void in case of gift, creation of agency. Say in agency, what happens is when you create agency, no consideration is required. Only when the work in agency starts, that time only you are bound to give consideration. Okay. So which is why just for creating an agency, you don't have to uh, give a consideration. Okay, no need to have a consideration. Charitable subscription, if you are doing charity, that's unilateral only, correct? So for this there won't be any consideration. Fine. Now, okay, next is now stranger to contract or doctrine of privity to contract. Okay, this is called as stranger to contract or doctrine of privity of contract. So what this says is, okay, a contract is between parties only and no third party can sue upon it. Contract is between only the people who have entered into it. No third person can sue upon it. Okay. Supreme Court, SC Supreme Court recognized this rule in this case law, MC Chaco versus State Bank of Travancore. Remember this, okay? MC Chaco versus State Bank of Travancore. Right? What was established? Contract is between the parties only and no third party can sue upon it. Okay? Right. So, fine. Now, under the English common law, only a person who is party to a contract can sue upon it. Okay, so we have picked from the English common law. So only the person who is party to the contract can sue upon it. That is, outsider cannot sue. In India, same applies, but the courts have introduced some exceptions. Okay, where it will not apply. Right? So Contract Act 1872 is silent about right of a stranger to contract to sue. The Contract Act is saying nothing, neither yes nor no about right of a stranger of the contract to sue. So basically, if there is nothing not written in the contract, that right is not there. Okay. So, which is why, as per our law, we can say expressly nothing is written, but stranger to a contract cannot sue. Okay, that's what is the position. So now we will have to see, we have seen here, courts have introduced some exceptions, correct? What are the exceptions of the court? That we will see. Okay. Circumstances where strangers can sue. So there are some circumstances which courts have allowed stranger can sue. And when we go through this, you will understand why strangers can sue. Okay. Why it had to be given. Okay. So beneficiaries under trust or charge. Okay. When there is a trust, okay, you will normally what happens? You have an author of the trust. Okay. You have an author. One person has created a trust called author. He appoints some trustees to take care of that property. Okay. And this property has been taken care of for some beneficiary. Now, the contract is between whom? It is between the author and the trustee, correct? Contract is between these two, right? As per the contract, trustee has to ensure benefit to the beneficiary as per what is mentioned in the trust. Okay. Now say in future this person dies, right? Then this beneficiary must have a right to claim it from the trustee, correct? So that's why here stranger to the contract, which is the trustee, has the right to sue the trustee. Stranger to the contract of trust, okay, who is the beneficiary, can sue the trustees, okay, or the trust. Fine. And second is marriage, settlement, partition, family arrangement. See, when marriage, okay, is a contract between two people. Okay. So marriage also has, it has the status of a contract because there are certain uh, commercial things which are to be given. Okay. Either at the time of marriage or at the time of separation, you have some money which might have to be paid. Okay. It is treated as a contract to that extent. Now, when two people marry, okay, and if say there is some problem and uh, they have to get divorced, okay, then what happens is normally the elders come and they negotiate, correct? Elders, this only happens. So in this case, that's why you need to allow stranger to the contract to sue. If for a, say for the divorce she has to sue, her parents also on her behalf should be able to sue. Okay. In this case, it is allowed because of the nature of the contract. Okay. So acknowledgement or estoppel. Okay. An estoppel is a type of contract. Okay. Estoppel is a type of contract. Okay. Here, what happens is in estoppel, you are taking a stance. Taking a stance means if there is another person, okay. Let us say there is another person, okay, and you are just saying that, say you belong to a certain bank, okay, you are saying that you belong to a certain bank, not belong to a certain bank, and you have that kind of dress and all that, okay, and you are trying to make a deal with him as if you are a person of this bank, okay, whereas you are not. So now in future, if because of what you have done, this person has suffered a loss of whatever it is, okay, 50K. If you have suffered a loss, then you cannot deny that you have no relation to the bank. You cannot say that I have no relation to the bank. Whatever you have said, on that basis, if he has suffered a loss, you will have to pay him back. That is called estoppel. Okay. So estoppel means if you have taken a stance and based on your stance, someone has taken a decision, then you cannot deny it again. Okay. Understood? What is estoppel? This is called estoppel. So here, so in estoppel also, the stranger to contract can sue if the stranger to contract has been affected because of your estoppel. Okay, you have shown as if, okay. Another thing, another easy way to understand is like this. For estoppel, say there is one person, okay, right, a prominent person, okay, a prominent person is there, and say you are an entity, okay, there is a third person. Now this person, and you have showcased as if this prominent person is with you, okay, this prominent person, he is your brand ambassador or whatever it is, like he has taken a guarantee or whatever, you are trying to establish this. So this person has entered into a contract with you thinking that you have his backing, okay, right? This is also called another use of estoppel. So you have said that uh, you have some relation with this prominent person and then you have made the contract, okay. So in future you cannot deny anything. So what if you have falsely done something, so just to get benefit, sometimes in future if you deny, you will get benefit, okay, but you cannot deny it. Law doesn't allow you to deny. That is estoppel, okay. So in estoppel also, now stranger to contract can sue. Here in this case, that if the prominent person comes to know that you are taking his name and doing this, then he can sue, although he has no contract with you. Okay. Then agency, again in agency, there are three parties. Wherever there are three parties, the stranger can sue. Okay. Agency, you have what principal, the agent, and a third person. Okay. So agent has done something which is outside his agency powers. Okay. Right. Then or say, even let's say the agent has sold him something, and now there is some major defect in it. So that third person can sue the principal directly, although he doesn't have a direct contact with the principal. Okay. So that's why. So wherever there is third party, three parties arrangement, the contract will be between two parties, but the third party will have a right to sue. Okay. Assignee in case of insurance policy. Insurance same as in case of beneficiaries. Okay. In insurance, say you take an insurance and you give some beneficiary. We put beneficiaries in insurance office and all, right? So if tomorrow you are not there, your beneficiary should be able to sue the insurance, right? If he's not paying the money, right? So that's why same thing. Circumstances where stranger to contract can sue. Fine. So these are the 5 points you should remember. You can write one sentence on it. But the main points are important. Write the main points, and so just write one sentence, but main weightage will be on these things. So estoppel is nothing but changing stance. Okay. Okay. So next is legality of object. Okay. So we saw that the object should be lawful object, correct? In essentials of a contract, we saw that object should be lawful object, right? So in contract, the subject matter of the contract, okay, is its agreement. Sorry. Subject matter of the agreement is the object. Okay. It is the object for which you both are dealing, right? Your object is to get 10 kgs of rice. Because of that, you have gone to the shopkeeper. Okay. So contract is the central thing. Okay. So now we had 2 points in essentials of a valid contract. Okay. One was lawful object and lawful consideration, correct? 2 things were there. Now both are covered here. Okay. Consideration or object is lawful. So they are saying it is lawful unless. Unless means they are saying what are the exceptions. If it is not lawful, if it is forbidden by law, is of such nature that it would defeat the provisions of any law. Okay. So this is similar to this, but here, second point, it is not expressly forbidden. Okay. It is not expressly forbidden, but if you permit that, then some other provisions of law will get affected. It happens sometimes. Okay. So this is an indirect effect on law. This is directly forbidden. Okay. So these two are, if these two things happen, consideration or object will not be lawful. Okay. Third is if it is fraudulent. Okay. Involves or implies injury to the person or property of another. Nothing can be allowed which causes injury to another person or his property. Fine. Then court regards it as immoral or opposed to public policy. So these are the points for lawful object and lawful consideration. Okay. When it will not be lawful object or lawful consideration. When these things happen. Okay. All these things. Right. So we'll see examples of these. Right. These same points. Examples. One is A, B, and C enter into an agreement to divide profit acquired by fraud. Okay. Profit is fraudulent. Okay. So the agreement is void as the object is unlawful. Okay. Then second one is A promises to obtain for B an employment in public service and B pays 1,000. So if you are paying some money for employment, is it legal? No. Okay. So it is void as consideration is unlawful. Okay. In certain cases, object can be unlawful. Like here it's the consideration, which is unlawful. Fine. Then A promises to drop a prosecution against B for robbery, and B promises to restore things taken. Okay, agreement is void. Why? Why? Because the object is unlawful. If someone has stolen anything, okay, from you, okay, one person has stolen anything, and now he's saying, so uh, you have gone to the law, okay. So now this person says, if I will give back everything which I have taken, take back the case. You are saying, okay. Will the law function like that? For the law, he has done an illegal thing, right? Whether he returns it or not, law will proceed against him. And when law proceeds against him, whatever proof or whatever they want from him, they will want from him also, correct? Right? So when anything illegal has done, you cannot just put it back in the same place and say everything is fine. You have still stolen it, correct? Even if you have returned it, before that you have stolen it. For that, you will be charged upon. Okay? Fine. Okay, A's estate is sold for arrears of revenue. Okay, so here what are they saying is estate is sold for arrears of revenue. You have to pay land revenue, right? For many things, we pay property tax, like that. For many lands, you have to pay land revenue. Okay, so sometimes if you do not pay land revenue for a long time, there is too much of arrears, then government will confiscate your land. Okay, so A's estate is sold for arrears of revenue. So government, when it confiscates, it will sell it and it will take the money, whatever is required, and whatever balance they'll pay it back. Okay, so A's estate is sold for arrears of revenue. Defaulter is prohibited from purchasing the estate. Okay, so when they sell it, there was one condition, government's conditions are there always, right? The condition is that the same person cannot buy it again. The person who has defaulted, because of which government is selling, he is prohibited from purchasing it again, okay, as per the conditions. So now what B has done, B upon an understanding with A becomes the purchaser, okay, and agrees to convey the estate to A. B is saying, now A is forbidden, right? B is not forbidden to purchase. So A is just entering into an agreement with B. You purchase, later on you sell to. So here this is an example of defeating the purpose of law, which we studied in the second point, right? I showed you. So this is basically law is not allowing him to buy. Now he is finding a way to buy it again, right? So that is defeating the purpose of law. Clear? Okay, so the agreement is void as it would defeat the object of law. Fine. Now next is okay, A, who is B's Mukhtar, promises to exercise his influence with B in favor of C. Okay, what is Mukhtar? Anyone knows? Heard about Mukhtar? Okay, Mukhtar is like Sarpanch. Sarpanch you would have heard, right? Head of the village. There's another word for that. Okay, Mukhtar means it is the head of the village. So A, who is B is Mukhtar, promises to exercise his influence with B. So A is B is Mukhtar, B is Sarpanch. So he will have some exercise on all the villagers, correct? Sarpanch has some authority on the villagers, correct? He says that he will exercise his influence on the villager, and then he takes some money from another person. So the Sarpanch is exercising his influence on a villager because some other person is given him some money. Okay, you use your influence and then do it for me. Okay, and he is promising to pay him 1,000. It is void because it is immoral, correct? You cannot take money, and your powers are there for your legal use. You cannot misuse it. Okay, right? So agreement is void because it is immoral. Fine. Last is A agrees to let her daughter to hire to B for concubinage. Okay, the concubinage is something where if there are two adults who are staying together illegally, okay, uh, that kind of thing. Okay, so if A agrees to let her daughter to hire to B, agreement becomes void because it is immoral, though the letting might not be punishable under IPC. Sometimes such letting it is not punishable because it is not against the will of the daughter. Okay, whether it is against the will or not, it is still illegal. Okay, so because it is immoral, right? So which is why it is void. Fine. Any questions you should have till now, you can ask me. Any questions so far? No?
No, sir.
Well, okay. So after today, it will be your class will be next week, right? So just you should revise till here. I will send out the notes. Okay. Uh, now itself after your class, I'll send out the notes till here. Okay. Just keep pace with me. That's all. No need to go ahead. So I'll only give you whatever is required. Okay. As and now we go ahead, I'll keep on binding it and give you consolidated notes. Okay. Just go on studying. So now after this chapter is over, I'll give you a written test on it. But you will have, I will load some objective questions in the app. Okay, I'll send the link in the group. Give me a couple of days, I'll send it till whatever we have completed, and you can just do those objective questions. Okay. Right. So now, so this is next part is e-contracts. E-contracts are electronic contracts. Okay. So e-contracts are paperless contracts in electronic form. It's a contract modeled, specified, executed, and deployed by a software system. Okay, directly a contract is being generated by a software system. Okay, conceptually very similar to traditional contracts. They have the same basic elements of a contract. That is, essentials of contract. Everything is same. Only thing is that it is not physical. You use a digital signature to sign it. Okay, that is generated through a contract and it is digitally signed. So when you are giving a document which is digitally signed, okay, you are as liable as if you have signed it yourself. Okay, that's called e-contract, right? So ingredients of the e-contract same as essentials of a valid contract. Okay, same as essentials of a valid contract. Right? These are ingredients of e-contracts. So ingredients of e-contracts, if it comes, you will write essentials of a valid contract. Right? I have not written this again here. Okay, because it is the same thing, you have to repeat it anyway. Okay, then you will get confused what is there, what is here. So it's the same as, so e-contract is a contract only, right? Only you are doing it through a software. That's all. The position of offer, acceptance, consideration, nothing changes. Okay, so main feature of e-contract is what? Okay, the main feature is speed, accuracy, and reliability. Okay, speed, accuracy, and reliability, and you have to obtain a digital signature. Both parties must have a digital signature. Okay, and so digital signature is used instead of manual signing. So whenever you say you buy certain things from Amazon and all that, okay, so the Amazon website itself is the offer for you. So when you go inside, you click and you pay through an electronic system only. You'll be paying either Paytm, Google Pay, okay, or your bank account. That becomes an e-contract, right? So in that case, you do not have a digital signature, but you are accepting that contract and paying for it, paying that amount. While paying that amount, you log in, right? When you log in for paying, that becomes your digital signature. Okay, that's deemed as your digital signature. Okay. So the Information Technology Act regulates e-contract. Okay. So not only Information Technology Act, Contract Act plus Information Technology. Okay. To the extent of things in the which are there in the information technology, that will regulate. Otherwise, all other conceptual things from the contract. Okay. In this type of contract, website of the offerer acts as display. Right? In Amazon, the website is display. That itself is the offer. Okay, the Amazon person is not coming to you personally and saying buy this. Okay, when you are opening, you are seeing that and you're clicking on it. That means you have accepted that offer. Okay, right? So like basically, I mean, you can see it and then when you pay it, that means you have accepted the contract. Okay. So emails are used to negotiate and agree on the contract terms and send and agree to the uh, send and to agree to the final contract. So basically, these are e-contracts. So you will be using any electronic means only, correct? In Amazon and all, you will not send an email, but after you buy, they send an automated email, correct? Get we have got this. So this is about e-contract. Okay. Short note of 4 marks is possible. Fine. In this e-contract. That's all. There's nothing much in it. Okay. Nothing which is required from your end. 4 marks. So now next part is constraints to enforce contractual obligations. Okay. There are some constraints for to enforce contractual obligations for you. Okay. So it means that it is stopping you from enforcing contractual obligations, right? So one is capacity of contract, capacity to contract. Who is capable of contracting? Okay. So that's what we are seeing. So capacity to contract is nothing but you are reading constraints to enforce contractual obligations. Same thing, both are. Okay. So who is competent to contract? Now this is section 11. Okay. So what it says is, see, who is competent to contract? The person who is of majority, sound mind, and not disqualified from contract. Okay. These three things are there. See, every person is competent to contract who is of the age of majority according to the law to which he is subject, who is of sound mind, and is not disqualified by contracting by any law to which he is subject. So three things are there. Okay. One is majority, sound mind, and not disqualified to contract by law. Okay. So don't learn this. Okay. No need to learn. So who is not competent to contract? That you can pick from these 3 points only. Okay. Who is not of the age of majority means what? Who is a minor? Okay. Person of unsound mind, right? And person is disqualified from contracting. They are not qualified to, not competent to contract. So what is minor? Minor is defined as per section 3 of the Majority Act. Okay, Indian Majority Act, which says that any person who has not attained the age of 18 years is a minor. Okay. Now there is one normally, so it is 18 years is the age of majority. But there is one specific thing, okay, where minor whose property or person, for whose property or person a guardian has been appointed under Guardians and Wards Act. There's a Guardians and Wards Act. Okay. If a guardian has been appointed for you, then for that person it is 21 years. Okay. Right. So if the guardian has been appointed before he has attained 18 years, if the guardian has been appointed, then till 21 years he will be a minor, like till under 21 years. Okay. So this is just one point which you should, normally it is what, 18 years. Otherwise, if guardian has been appointed, caretakers are appointed, right? Sometimes. So in that case, when guardians are appointed under Guardians and Wards Act, then it is 21. Okay, fine, right? So it says, are you over 18? Right? If you're over 18, you are over 18 means 18 or over, you can say. Okay, so you please go on mute.
Oops.
Okay, so minors, so minors agreement. So about minor, what we are saying is minor is a person who has not attained 18 years. Okay. So we'll see more about minors agreement. One is agreement with the minor is void ab initio. So I told you about ab initio, right from the very beginning it is void. Okay. And law of estoppel does not apply to a minor. It means minor can say that I am a minor, although initially he has misrepresented as a major. Okay. So if say for example, for minor, there are lots of protections under the contract. So, which is why you have to should be very, very careful before dealing with the minor. All the laws will fall with the major. Okay. So, here, for example, what happened is a minor. Okay, he is saying that he is a major. Let us say he is 17 years of age. Looks like a major. Okay, he is saying he is a major and entered into a contract. After enter into a contract, okay, he can plead his minority. That means he can say that no, I am minor, so I am not competent to the contract. So now the contract will not be binding. Okay, so which is why if there is any loss, he has dealt with this person. Now this person has a loss of 50K, which the minor has to pay, and he has pleaded his minority now. And this 50K will be a loss for this person. Okay. So law of estoppel does not apply to minor. This is one exception. Fine. So doctrine of restitution does not apply to a minor. Restitution means restoring something back. What is restoring something back is like here in this case, which the example which we took here, restoring this 50K back. Okay. So general law of contract is if you have taken anything illegally from anyone, you have to restore it back. You have to restore it back to that person. Okay. So, but it does not apply to against a minor. So this is one case law here, Mohri Bibi case law. So it's called Mohri Bibi versus Dharmodas Ghosh. Okay. So here what happened is like Dharmodas Ghosh was a money lender. He gave some money to Mohri Bibi, who was a minor. Okay. Then she did not give it back. So then the doctrine of restitution was said not to apply. So he could not get his money back. So we should be very careful while dealing with minors because they have all the facilities. Okay. So this is the thing in general. So I have explained to you what it is. So here it was said that contract with minor is not voidable but absolutely void ab initio. Okay. It is not voidable but absolutely void ab initio. Not that it has become void now. It is fully void and restitution does not apply. Okay. So third one is restitution does not apply. Then next point is no ratification on attaining majority. Ratification means sometimes say meaning of ratification is say if your child has gone to a shop, is asking for something big, let us say some 1,000 item is asking. So what the shopkeeper will do, he will call the father if he knows him, right? So he will call the father, sir, did you send the child for this? Okay. If he says yes, this is called as restitution. Okay. This thing is called as restitution. Okay. So
It's called ratification.
true. So that's not restitution, that is ratification. Okay. It's called as ratification. You are ratifying this thing. Okay. So basically, whatever the child is saying, you are ratifying. That is, in other words, we can say you are seconding it. Okay. So this is your fine. So this is your uh, another point of minority. No ratification on attaining majority. So when the minor becomes a major, he cannot say that I want to ratify my contract before. Okay, because law says contract with a minor is void. So after becoming a major, he cannot ratify it. He can go for a new contract. Okay, whatever are the conditions on that date, based on that he can go for a new contract. But that old contract which he made as a minor, that will be void. Okay. So you cannot ratify also. Okay. So here I have used the word child here just to explain you what is ratification. Okay. Fine. So this is not from a contract point of view, but just to tell you what is the process of ratification. Okay. Okay. So this is the same thing which I have explained you already. Okay. Now next is contract to benefit a minor. So if there is something which is benefiting a minor, then he can enforce that contract. Minor can enforce contract with benefit. Okay. Minority is a personal privilege and he can take advantage of it. For example, if say minor has a contract with a school. Okay. So minor is saying that he is an adult and he has taken some work in the school. Okay. Some work. So the school has given him some education, free education. Okay. Later on, it was found that he is a minor. So the contract got cancelled. So when the contract will get cancelled, this free education will not get cancelled. Okay. This will not get cancelled. It's a personal privilege and he can, whatever advantage he is getting out of the contract, he can take it. Okay. So you can see how much privilege minor has. And so more dangerous are those people who are around that 17, 16. Okay. So where they understand everything. Okay. But just use that minority to defraud others. It does happen. And things is some people, some who are around 17 years of age, they look like 19, 20 also in many cases. Okay. So these are the privileges which they have. Okay. So now minor as an agent, minor can be appointed as an agent. Okay. But tomorrow you cannot go back to him if he doesn't pay you. If he pleads his minority, then you will have no restitution. You cannot get back anything. Okay. But there is nothing that minor cannot be an agent. He can be an agent. Okay. But it's your risk. Minor is liable for necessaries. If some person is supplying to the minor, okay, something, some necessaries for his life, like kirana or things like that, then minor's property is liable for it, but minor is not personally liable. Okay. So if the minor, he has the means of paying the amount, then he has to pay, right? Anything which is his necessities. If someone is giving him, he has to pay. Okay. Right? Minor is never personally liable. So difference between not personally liable is, if he's not personally liable, you can never send him to jail for anything. Okay. Then minor cannot be judged insolvent as he is incapable of entering into a contract. Now he is not competent to contract. So insolvency is a contract basically. It's a insolvency means that you have entered into a commercial contract and now you don't have the assets to pay it. So your whatever assets are there, they are distributed, okay, and you are declared as an insolvent. So minor cannot be adjudged as an insolvent. So basically, what will happen here? If he cannot be judged as an insolvent, right? So what will happen? So whatever money you have given to him, that will remain his. When you are adjudicating someone as an insolvent, so whatever money he has for property, you can have it sold and get back at least something, whatever is there. You cannot do that to a minor. Fine. When a minor and an adult jointly enter into an agreement with another person, okay, minor plus one adult, both are entering into an agreement. So then what will happen? The major will be held responsible. It can be, if tomorrow minor pleads minority, whole contract will come on the head of that major. Fine? Understood? Okay. Right? Next point is sound mind person. Okay. Who is considered as a person of sound mind? Three things we saw. Okay. Minor, sound mind person, and incapable of contracting. 3 points we are going through. So who is a sound mind person? Okay. He is a sound mind if he is capable of understanding it. Okay. If he is capable of understanding it and forming, just see the colored part. Okay. In these notes I have gone through, given many colored parts to you. So when you read, you can read quickly. Just follow those colored parts. You'll get complete knowledge of it. Okay. So what is a sound mind a person is that if he is capable of understanding it and forming a rational judgment as to its effect upon its interests. So two things are required. One is he is capable of understanding it. He's understanding it and he's also able to understand what effect it will have on his interest. Then he is a sound mind person. That means sound mind is not just a lunatic. Okay. So a person who is very old, 85, 90, is not able to read and understand. He is also a person of unsound mind. Okay. So, or a person with very low IQ or low intellect is not able to form an opinion of a contract on his interest. Then for contract act, he is an unsound mind person. So remember that. Unsound mind doesn't mean lunatic and he is there in the lunatic asylum. Okay. Sound mind here is anyone who is incapable of understanding a contract and forming a rational judgment on it. Okay. And now here one more thing is, if a person is usually of unsound mind, but occasionally of sound mind. Okay. It happens like people of sound mind, they are not always of unsound mind. People of unsound mind, correct? So they are fine many times. So a person who is usually of unsound mind, but occasionally of sound mind, he can make a contract when he is of sound mind. So at that point of time, he was capable of understanding it and forming a rational judgment. That is important. Not that later on he became a lunatic. Okay. And similarly, a person who is usually of sound mind, but sometimes of unsound mind, he cannot make contract when he is of unsound mind. So whenever this person is of sound mind, he can make it. If a person normally is of sound mind, sometimes he get drunk and at that point he is not understanding anything. Then he cannot contract during that point. Okay. So if anyone has entered into a contract during such time, then the contract will become void. Okay, so here are some illustrations. Probably we're in the last 2 minutes. Okay. Illustrations is now a patient in lunatic asylum who is at intervals of sound mind may contract during those intervals. Okay, we saw that. Next is normally a person who is sane. Sane means whose mental state is fine, but is delirious with fever. Delirium means when you are not understanding anything and okay, you are in some sort of attack. Okay, if you are delirious from fever or is very drunk that he cannot understand the contract. Okay, so he cannot contract while delirium lasts. So if he does contract, later he can prove that he has contracted during that time, then it will become void. Okay, fine. Thus, a person is of sound mind if he is capable of understanding the contract, capable of forming rational judgment upon his interest. Okay. If not satisfying any of these two conditions, is not treated as person of sound mind. This is a very, very important part. Okay. This is an extremely important point here, which tells you that as per contract act, unsound mind is not only those who are in the mental asylum or who are mentally incapable, or I mean, who have some mental problem. Okay, it can be anyone. It can be an old person. It can be a properly healthy person whose IQ is low. Okay, right? What is IQ? Now, what is IQ? Intelligence quotient. Okay, intelligence quotient is it is judged. It has a score, and this score tells you the ability of the person to act in various circumstances. Its capability, basically. That's what we call as IQ. Okay. Less IQ means less capability. Okay. Fine. So that's it. So I'll close this. This other disqualified person, a persons we will do in the next class. Okay. We'll start from here. Fine. So you have any questions, you can ask me.
No question, sir.
Okay. Anyone else? Any question? Okay then. Okay. So fine then. So we will meet in the next class. Now, tomorrow you will have cost accounting. Okay. Same time, 6 o'clock, cost accounting. Okay. See you then. Okay. Thank you all.